Hey everyone, Harry here to talk about the brief filed by Jack Smith for the Department of Justice in the 11th Circuit challenging Judge Aileen Cannon's dismissal of the whole Mar-a-Lago prosecution. Okay, first, to review her theory for dismissing, her idea, and it runs directly contrary to court after court after court, starting from the U.S. Supreme Court, is that under Article 3, the president, to appoint principal officers, they have to go by the Congress, but subordinate or inferior officers, Congress can provide for their appointment by law, which means, there's some mechanism that Congress has passed to express their okay. And what she found, there were many different kinds of laws that every other court who has considered this has said, well, that's perfectly fine. That's a statute that gives authority to the Attorney General to appoint a so-called special counsel to help out. She alone decided otherwise. Now, this is not, even though she made it sound like a big Constitution separation of powers case, it isn't. This is not the same kind of challenge as there was to the whole idea of independent counsels. Remember, that happened. It was approved by Morrison versus Olson, but led to results that many people balked at. And so this regime now for special counsels is within the Department of Justice under the Attorney General, and the Attorney General has a regulation that DOJ has promulgated that provides for these special counsels to be appointed. So it was under that Merrick Garland appoints Jack Smith. Also, by the way, that Merrick Garland appointed the special counsel who looked into President Biden's retention of documents. Also, that Merrick Garland appointed, after some delay, David Weiss to be the special counsel prosecuting Hunter Biden. So it's this regime that has been widespread ever since it was enacted in the wake of the sunsetting of the independent counsel statute. So for it to be okay under the provision about how you can appoint people, basically there has to be some statute, something that Congress has done to give the Attorney General authority to appoint special counsels, and that provision has to be okay under the Constitution. All right, so there are several in play, and now we have, so Aileen Cannon marches through each of them, and completely contrary to court after court says none of them passes muster. This one, it talks about retain. Well, that's not the same thing as appoint. And then, she gives pretty unsatisfying distinctions as to each of the three statutes. But then, in addition, there is a really important quote from U.S. versus Nixon itself. Just to double back, I don't think we have to go through these completely, but there's section 515 where the Attorney General can appoint special attorneys like special counsel. That's from Congress. There's 2 in 515, 515, etc. So they go through 3 and say why all of them meet. But then more generally is this 533 is the third. And then there's this big chunk of determination from the Nixon case itself. U.S. versus Nixon is the case where Richard Nixon was ordered that he had to turn over the tapes. It basically brought down his presidency. And here's what the court unanimously wrote in U.S. versus Nixon. Congress has vested in the Attorney General the power to conduct the criminal litigation of the United States government. That's just true, right? That's got to be true. It has also vested in him the power to appoint subordinate officers to assist him in the discharge of his duties. And they quote 28 U.S.C., those are congressional statutes 510, 515, 533. There are two others that the department talks about, but those are the big ones. And acting pursuant to those statutes, the Attorney General has delegated the authority to represent the United States in these particular matters to a special prosecutor. All right, that describes the authority for Jack Smith. It describes the authority as well in the Hunter Biden cases, the Joseph Biden cases, and the like. So after there is this back and forth about 509, 510, 515, and 533, and why all of them and any of them sort of fit. But then, I mean, here you go. It has also vested in him the power to appoint subordinate officers to assist him in the discharge of his duties. If that is right, Aileen Cannon is wrong. I'll say it again. If that is right, Aileen Cannon is wrong. So what Aileen Cannon did was try to dismiss that statement that's been cited for decades by different courts and say that's just dicta, a phrase that even non-lawyers out there may have heard to say, you didn't need to make that statement in order to reach the holding that you did. Therefore, it's not necessary to the holding, so we really can't take a court to have decided it. So a big thing DOJ does in its brief is say, no, that's exactly wrong. This is not dicta. Rather, this is something that was central to the court's determination that there was a case between the special prosecutor and the president, and it was a necessary antecedent to determining whether the regulations were valid. So the court necessarily had to decide this sentence rather than being sort of stray surplusage. The statement that says the Attorney General has the power to do it is necessary to the decision. So again, if that's right, not just a Supreme Court case, but a really long-standing precedent. I think Justice Kavanaugh cited as one of the great moments of the Supreme Court, 9-0 refusing the president, the kind of thing that they exactly decided not to do in this most recent case. Anyway, the argument is Nixon means just what it says, and it had to mean it, so it's not dicta. And also these three different statutory provisions, 515 and 505 and 533, if you look at them closely, they provide that authority as well. So that is the basic argument. Oh, there's one other point to the brief where they say, and in addition, you, Judge Cannon, expressed a question whether or not the Congress has the proper finances to fund the special counsel. Guess what? It totally does. There's this residual fund. Totally, we can fund from there, so that's not a problem. She didn't actually go off on that, but she cited it as a potential worry. Okay, that's the brief. What's not in the brief? Any discussion of the need to recuse her. So that's the main thing that people have really focused on. They go through all this stuff. These are the arguments you could have expected them to raise. They raise them cogently. They raise them solidly, especially Nixon. They really make a showcase of saying, here's why the statement in Nixon, which, if true, is not dicta, but rather really matters. But such an elementary error, right? So by their statement and analysis, Cannon, has failed to follow the most elementary law, has departed from, every other court has decided it up to and including the U.S. Supreme Court. You might think that sets up a platform pretty well to say, as you would just say in a sort of line at the end, we also would recommend or ask the court to let us be heard on the question whether, if you do decide to reverse, she should be recused when you return the case back to the district court. Because the law of the 11th Circuit is that when there's been a pattern of fairly elementary errors, and remember, she's started out here with the blunders with the whole misadventure letting Trump challenge the search warrant, and they had to, the 11th Circuit, reverse her really pretty sharply and seriously. So you add those to this, there seems to me and to kind of everyone, at a minimum, a very good argument. It would be completely down the middle, not overly aggressive to be saying, and you should recuse her. And it's also very hard to see a better chance. And with this decision, among others, she really has shown her stripes. Many people have concluded, I'm among them. She's, as long as this case is hers, she's gonna do everything she can to foil the United States. And she's made a lot of feints in the direction of making rulings after trial begins here that would be impossible to reverse. So why didn't they add to their brief a little line that says, oh, and you ought to recuse her? A lot of people scratching their head about it, a lot of people talking about it. Now, it could be that they've decided to just be passive and leave it to a court. To me, that would be kind of a misstep. I mean, there's nothing, as I say, that would be overly bold about doing this. It really follows. So it could be that they've calculated that they'll have another shot, that the 11th Circuit will ask them maybe at oral argument, and that's happened. It's happened to me. Are you seeking a recusal? And that they'll be able to say it then, and they want to just set up their legal argument first. But it's not assured, and it doesn't look as if it's something they could just do in their next brief on the reply brief. So maybe it's a gambit to make the recusal motion later, or maybe they've decided not to, and in the calculation of the everything that's in play here, which is complicated and messy, and they're thinking what it looks like after the election, if and only if Trump loses, because if he wins, he just orders it to go away. But even weighing all those in the balance, it's noteworthy and odd, I think, that they didn't move for recusal, and my best guess is they're thinking of doing it down the line, and they think they'll have another chance. Others think that's not going to be easy for them to do, and they've whiffed on it. So that'll be a story to be told in a few months when we actually move toward oral argument. For now, all the arguments strong in there why she should be reversed, but not why she should be recused. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.